Hello everyone and welcome back. In this video I'm going to be talking to you about using the Baker Act to treat a mental health issue, especially one that seems to be driven by marijuana. So I've been pretty vocal in the past about how dangerous this new this new legalized marijuana is. And actually there were two things that really changed the dynamics of the cases that we handle here. From primarily drug and alcohol back in 2016 to now primarily mental illness. The first one was COVID, and the second one was the legalization of marijuana. As a child of the 80s, I had a lot of friends who used marijuana. I didn't think it was going to be a big deal, but it turns out that it is a big deal, and I was wrong about the possible effects that it would have. The marijuana of today, whether you get it from one of these dispensaries or even on the streets, because we see that a lot, is not the marijuana of the 80s. This stuff is dangerous. It will damage someone's brain permanently. It will cause paranoia and delusions. And if there's any genetic predisposition for mental illness, it is like pouring gasoline on a fire. And so I am very much against using marijuana, especially for recreational purposes. Does it have medicinal use? I think that it can do. I've heard that it can do. So I'm not 100% against it for those purposes. But if you're somebody who is in their teens or early 20s and you're using this stuff, it will damage your brain. There's no question about it. And it's a gateway drug, which means that at some point you'll probably progress into something a little heavier to give you the same high or stimulus that you were getting from the marijuana. But what we're seeing is a lot of mental health cases that are fueled by this use of marijuana. And in one particular instance, an unsuspecting mom, basically had her son go to a Baker Act facility and said, he needs to be assessed for mental illness. Can you help? And they said, well, does he have health insurance? And she said, yes. And they said, great, of course we can help. Sign here. And, what she had unwittingly signed was a voluntary admission agreement. And now, having, realized what's going on here, having revoked the consent, the facility, which is one of the, the most unscrupulous facilities that we litigate against, has filed a petition to keep him. And there will be a hearing at some point in the next 5 days for a judge to decide how much longer this individual is going to stay. And I said, I don't think that he meets criteria. I don't think he ever did. First of all, he wasn't necessarily harmed himself. He wasn't threatening to harm himself. He hadn't tried to harm himself or anybody else, but he is using marijuana. And I think that there are other ways you could have dealt with this. And I know that you didn't realize this, but you've got sucked into Florida's mental health system. And if we don't try to get him out rather quickly, he's going to get stuck there. Oh, and by the way, this facility, knowing he has health insurance, is giving him all kinds of pills and whatever else that of course is not helping him. In fact, it's making him worse. And I said to her, I've seen this before where a Baker Act facility will intentionally medicate somebody in order to destabilize them and therefore to build a case and say, look, judge, look how terrible this person is. We need more time. We can't possibly fix this in a week or even 2 weeks. We're going to need a lot more time. How about a month or 45 days? And I've seen this happen. And so the Baker Act, number one, is not a treatment statute. And number two, it is not designed for somebody with a substance use disorder, i.e. the use of marijuana. In fact, the statute specifically excludes substance use disorders as criteria for detaining somebody. Now, part of the problem, or the main problem with the Baker Act is, of course, once you're there, nobody knows you're there, so the facility doesn't really care because nobody's watching them. And of course, the other big problem is that absent them physically damaging you, you can't sue them for this, well, because they're an agent of the state's mental health system and, well, they enjoy immunity. And it says so right there in the statute, just in case you want to see for yourself. So if you have a loved one who is dealing with marijuana-induced mental illness, I think there's a couple of ways to address it. One is the Marchman Act, and the other is the guardianship. And if you can, if you have the resources to do both of them at the same time, I'm a big fan. I believe in having max control over an out-of-control situation. Using the Marchman Act in conjunction with the guardianship is the way to do that. So I just wanted to clarify that. Please, 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 please don't use the Baker Act to get your loved one into treatment, and please don't have them going to a Baker Act facility when the issue is substance use related. Because unfortunately, if you do, then you run the risk that this poor unsuspecting mum did, which is that you get stuck and now the facility wants to keep you. So I hope that helps. I appreciate you tuning in. I would love a thumbs up and a subscription to the channel if you can. And I will see you in the next video. Bye-bye.